Good morning, good afternoon, good evening to all the participants and attendees gathered here. I extend my heartiest welcome to Mr. Yilli, who is going to be the special panelist for today's webinar, and to Mr.V.Inbavijayan, who is a project advisor, and to Ms.Sameena Syed, who is going to be the moderator for today's session. So this is the second webinar on the sector-specific series of KFCRI webinar series. So, on completion of the first sector-specific domain name disputes, now we are in the investment arbitration sector-specific webinar series. So this webinar, investment arbitration webinar series is of 2 days session. The first day will be dealing with the topic on a brief overview on investment treaty disputes and an introduction to the investor-state disputes with reference to the arbitration. So I extend my heartiest welcome to all the patentees gathered here. So I am Shanmugadev on behalf of the KFCRI will be the host here. A brief introduction about KFCRI before jumping on to the session. KFCRI it functions as 3 bifolds. One is as an institution, other as an accreditation body, other as a think tank. As an institution, KFCRI has its own rules for arbitration, mediation, conciliation, and even for the tribunal secretary and for other forms of area services. And as an accreditation body, KFCRI do the noble job of disseminate knowledge to the various professionals, and we accreditate the professionals based on qualifying the course on their experience and the qualifications on certain level of accreditations in KFCRI. As a think tank, KFCRI is promoting the role of ADR globally through many competitions and events, and one such is this webinar series. So before I hand over to Mr. Inbavijayan to give the introductory remarks and to have a welcome address, I just want to stress on a few of the housekeeping rules. I would request all attendees, please do not use the chat box unless you are facing any network glitches, and please put your questions now and then. Thank you.
Yes, thank you, Shanmugadev. Good morning, good afternoon, and good evening, depending upon the jurisdictions where you are attending. It is an honor and privilege on behalf of KFCRI to invite Mr.Yilli Dautaj, who is the visiting lecturer of Uppsala University, Sweden, and a practitioner in investment disputes and arbitration. As a first of a series, as Dave was mentioning, today Mr. Yilli is going to share with all of us a brief overview on the investment treaty dispute, particularly an introduction to investor-state dispute in reference to arbitration. Anyway, the core element is going to be arbitration. To add on the very sector-specific, KFCRI is having an exclusive sub-project which is dealing on sector-specific. In that, as a first task, we are diverging into this investor-state. As an introduction, I'm very happy to introduce Mr. Yilli Dautaj, who got his law graduation from University College Cork, Ireland, and further he went on to do his masters in Uppsala University, I think where he got this interest on investment arbitration. Additionally, he has completed a master's in Pennsylvania state law and presently pursuing a PhD in University of Edinburgh, Scotland. As an academician, he is quite active, contributing the role in Uppsala University as a visiting lecturer, I think from Jan 2020 recently. And he is also associated with the Indian Institute of Corporate Affairs, very specifically the Graduate Insolvency Program. In the academic appointments, a very prominent blog, that is a Kluwer Arbitration blog. He is contributing as an editor, and to our interest, he is quite associated with India in O.P. Jindal Global Law School, as well as Nirma University Institute of Law. When it comes to GNLU, he frequently visits as a visiting lecturer since March 2019, particularly on the ADR front. When it comes to the contributions, the literatures, very recently he is working on the COVID-19 arbitration practice, the use, misuse and abuse, which is going to be a book chapter, a forthcoming book on emerging trends in international arbitration by Thomson Reuters. And I wanted to specifically mention, since it's an investor state aspect, he is contributing, he is likely going to come out with a very interesting guide on Sweden Investor State Arbitration Laws and Regulations 2021 in the International Comparative Law Guide. And we can add on, I think he has a good number of academic penetration, you can say, on investor state as well as in arbitration. But as a lawyer, he is now a managing partner of Der Juridik, wherein he represents Swedish as well as international clients in litigation as well as in arbitration. Inter alia, it is investor protection also to be considering his practice. And he also involves in high stake and complex international arbitration as well as international litigation matters. With this few words from KFCRI, reading his profile, it's phenomenon for such an young practitioner to have so much of exposure and so much of reach, whether it is Central Asia, whether it is South Asia, whether it is Middle East, or whether it is European continent. He has reached to the maximum, and now we are having him to share a few aspects about investor state arbitration. Welcome, Mr.Yilli Dautaj.
Thank you very much. I mean, it is indeed my honor and my privilege to be here to speak to this great audience and with this great team of KFCRI. I am very honored and privileged indeed to meet virtually for now a professor and arbitrator, Mfn. Also, I want to extend my thanks to the team, primarily Ms.Sameena and Ms. Dev, and of course the entire team that is led under the auspice of this great arbitrator and professor. And these words I do not take lightly, and I appreciate them very much. So this is with, as I said, with my full honor and privilege that I deliver this lecture today. Thank you very much.
Thank you, sir. Thank you. Sameena, Ms. Sameena, we can start the webinar.
Thank you, Mr. Dev. Thank you, Mr. Inbavijayan. I deem it an extreme pleasure to be moderating this session, which has Mr. Yilli Dautaj as our keynote speaker. Mr. Dautaj, warm greetings from India. I hope everything is well and fine at your end in Sweden. So without any further ado, shall we begin?
Yes, please.
Mr. Dautaj, the first question that would pop in anybody's mind when I say investment treaty dispute is what is an investment treaty and what constitutes its nature. So could you please elucidate about what is an investment treaty, what are the kinds of investment treaty, along with their differences and similarities?
Yes, so that is actually a very good question, and it sort of encapsulates the entire field of investment treaty arbitration. So the answer to your question is actually in the name. So if we break it down, investment treaty arbitration, it means that there is a dispute that stems from an investment, and such is regulated and protected under a treaty. That treaty, as you rightly mentioned, could have different characteristics. So that treaty could be a bilateral investment treaty, in other words, a treaty that is signed between two states. Typically, for example, India and Brazil just recently signed a new bilateral investment treaty that is a different kind of actually a different kind of investment protection agreement, but it could be typically an agreement between two states. And then you have the arbitration part towards the end, which means that if there is any such dispute is regulated under the auspice of arbitration. So an investor would request arbitration for an infringement with its investment that is protected under the applicable law of international investment law, that is provided for in an international investment agreement, typically a bilateral investment treaty, and hence the name, Investment Treaty Arbitration, ITA.
Thank you, Mr. Dautaj. It was indeed a very lightning one. Mr. Dautaj, an investor-state dispute is often referred as mixed arbitration or an interstate arbitration. In the view of the same, can you please tell us about the parties involved in the dispute?
So the parties involved in the dispute is also typically what signifies investment treaty arbitration. And that is, the claimant is typically, and I would say always, an investor, and the respondent in these disputes is typically, again, always, the host state. In other words, the state that is hosting the investor and the so-called protected investment. However, and we will come back to this towards the end of this session, due to the demand for transparency in these procedures, and that's because the respondent is always the state, or a state rather, there has been an increased call for amici participation. In other words, participation in the procedure in the form of international organizations, non-governmental organizations, or other types of institutions to give an opinion or a thought that may be of extreme public interest.
Thank you, Mr. Dautaj. Mr. Dautaj, can you tell us why an alternative mode of dispute resolution in the mechanism of arbitration is usually preferred in an investor-state dispute?
So this goes back to the fundamental elements of what arbitration actually is. And this is more or less the same answer in partly as with respect to commercial arbitration, but then we can also specifically highlight what makes arbitration even more compelling for an investor-state context. So first and foremost, I mean, it's a matter of party autonomy, which means it's a private adjudication which touches upon dispositive matters, and ultimately the parties to a dispute is in faith of their own litigation mechanism. So that's you know the initial perspectives of why we would, in a free society, cherish arbitration. In other words, free litigation. However, in this specific context, as we said earlier, the respondent is always the state. And therefore, arbitration provides for a neutral venue. And because it is a neutral venue, it actually strengthens and enforces the global rule of law. So the problem at the very inception with litigating investment matters, in other words, protection of investors and their investment, was that you had to do it at the host state's home court. And maybe that would be sufficient. I mean, we have no doubt, for example, to hesitate on the competency of the Supreme Court of India, which is very excellent. But if you're an Indian investor and you have invested in a up-and-coming, perhaps not such a strong rule of law in an African nation, as an investor, you would not perhaps be trusting the state without the assurance of having any potential conflict stemming of that investment litigated through arbitration at a neutral venue, which renders a final binding and directly enforceable arbitral award that can be enforced all over the world, more or less.
Thank you, Mr. Dautaj. This indeed tells us the importance of arbitration in an investment treaty dispute. Mr. Dautaj, we understand that the exit under the aegis of the World Bank is one predominant institution which deals with investor-state disputes. Can you talk to us about the role of the exit? And my next question, the follow-up question is, how is the arbitration procedure different between the countries who are party to the exit convention and those who are countries who aren't a party to the convention?
Yeah, so to answer this question, I would say that ICSID was the first and only convention that was established specifically for investment disputes. In other words, for investment treaty arbitration. In other words, ICSID was tailored for ITA, That is the short way of saying investment treaty arbitration, ITA. So I will use that henceforth, which was, as you may know, or may not know, but will be told now, was not the case with other institutional rules. Those rules were used solely and formed solely for the ICA usage. ICA is International Commercial Arbitration. And it should be added that albeit ICSID has done a great job, it has been a truly tremendous institution with a great rules framework, a great convention that has been truly manifesting itself as a central pillar of the international arbitration platform upon which we stand today. As we can say, even other institutions have now drafted rules that has been tailored to investment disputes. So for example, the Stockholm Chamber of Commerce or the International Chamber of Commerce, the ICC, are two other frequently chosen institutions for investment treaty arbitration disputes. Moreover, and this perhaps is more what you can relate to in the Indian market, is that quite some disputes are handled ad hoc. In other words, mostly pursuant to the UNCITRAL framework. And that is no bad in and of itself. It doesn't mean that the ICSID convention should be way preferable to the SEC or the ICC or to the ad hoc procedure pursuant to the UNCITRAL rules. It has been preferable. It has proved to be working, but so has SEC, and so has ICC, and so has actually ad hoc investment arbitrations under the auspice of the UNCITRAL regime.
Yes, thank you so much, Mr. Dautaj. Mr. Dautaj, investment is a core in any investment treaty. Could you tell us about the characteristics of an investment and what qualifies as an investment under any bilateral investment treaty?
So, generally speaking, and I will keep it very brief because this is a question that can throw up various significant issues to be handled from various different angles. But generally speaking, in investment law, we have something that has been formed and shaped as the Salini test. In other words, the Salini criteria, which states that an investment is a contribution of money or assets that is invested for a certain duration, that has an element of risk, and fourth and finally, which has a contribution to the economic development of the host state. So as you can tell, the last criterion there, in other words, a contribution to the economic development of the host state, is that which is the more cumbersome to overcome, generally speaking. Now, to give examples, investments could be, for example, investments in mines. It could be in the energy sector, for example, with respect to renewable energy, or could be brown coal. It could be various other types of energy. Equity is another typical sort of investment. Debt, property, in other words, not only property as such, but also in the construction sector, in which you, for example, would undertake to build a public hospital or a public park or something of that sort.
Thank you, Mr. Dautaj. Mr. Dautaj, my next question is something which fascinated me to get into investment treaty dispute resolution. The thing is with regard to rights and obligations. Can you please let us know what are the rights and obligations that are enshrined in the investment treaty, and why is the most favored nation clause, the national treatment clause, the expropriation clause, and the fair and equitable treatment clause considered very vital in an investment treaty?
Okay, thank you very much. So this is, again, this is a lengthier question, which can be elaborated. Each and every specific substantive protection can be written about extensively, and there are books on each, essentially. So, and we need to separate these two. So one is rights and the other is obligations. Typically, all bilateral investment treaties or other international investment agreements provided for protection and less of obligations, which India and the Netherlands has sought to redress or at least address. But I'll come back to that because that's more sensitive and timely, essentially. So there are several substantive protections used in international investment agreements. Some of the more typical, which Ms. Sameena now had mentioned, and I will stick to them, and I will provide a short explanation of each. So if we start with the Mfn clause, which is the most favored nation clause, it has two elements, I would say, to consider. One is the substantive angle of it, and one is the procedural. So the Mfn clause could, for example, be used to attract a substantive protection offered in another treaty. For example, to rein in an umbrella clause or an FET clause, which is applicable in another treaty, but not in the specific treaty in which you have an Mfn clause. And that is for the investor to avail of a higher set of protections. In other words, to obtain a right that was not originally there. But the Mfn clause makes it available by extension, by substantive extension. The other way to use an Mfn clause, which is a bit more controversial, so the first way to use it, I said, was less controversial, or least controversial, I would say. More recently, it has been treated as controversial. But more controversial would be the change of scope of application of the bilateral investment treaty, for example. And that would be to use the Mfn clause to, for example, broaden the definition of what is an investor, or broaden the definition of what more particularly, what is an investment. And then you have the most controversial aspect of the Mfn clause, which is to avail of an ISDS, in other words, Investor State Dispute Settlement Clause, arbitration, in another bilateral treaty, investment treaty, or an international investment agreement. So that would be, for example, if you have a bilateral investment treaty that does not give you the right to initiate arbitration, but another treaty does. So can you avail of the most favored nation clause to reach, you reach into another protection document, international investment agreement, and bring in the ISDS clause to avail of it through the Mfn clause. So that is the Mfn clause in short. We move on to national treatment. National treatment, I will read a typical language, which reads as follows, and I quote, "Each party shall accord to investments of investors of another party treatment no less favorable than that it accords in like circumstances to investments of its own investors with respect to," and this is important, "establishment, acquisition, expansion, management, conduct, operation, and sale or other disposition of investments." So the typical language can be adjusted and changed, and the same goes for the just touched upon most favored nation clause. You have to look at the specific language of the protection in order to analyze what it actually offers. And that is an exercise of textual interpretation under the Vienna Convention on the Law of Treaties. So if you're facing or representing an investor and you want to put forth a claim for national treatment, what you have to do is look at three things. First, you identify a group of nationals with whom to compare the claim. Then you compare the treatment of the two groups. In other words, you explain why was the investor treated less favorable than the national. And then you evaluate whether the two groups are in like circumstances, or if there will be a factor that could justify differential treatment. That could be. There could be a factor that could differentiate the treatment between the two. To move ahead, we come into expropriation. Expropriation is essentially a state measure that targets a specific investments. So it has an element of a taking by governmental exercise. I would also add to this that most problematic are indirect expropriations. So an expropriation is a clear taking of your investment. That would happen rarely nowadays, especially without compensation. Indirect expropriation, that is measures that are equivalent to an expropriation. And that could be a single measure that is less likely, or it could be a series of measures that over time constitute an indirect expropriation. And to this, I would add to all of those who are listening that a lawful expropriation is fine. As long as it is non-discriminatory, it is taken for a public purpose, it is in accordance with due process of law, and payment of compensation follows a specific standard, for example, the whole formula. That leads me into the protection of fair and equitable treatment, which has different schools of thought. So what is the standard of fair and equitable treatment? There is one school of thought that would say that it's essentially the same thing as fairness, equity, or reasonableness. Another school of thought refers to the very famous case of Neer against Mexico that said or held the following, and now I quote, "FET should amount to an outrage, to bad faith, to willful neglect of duty, or to an insufficiency of action so far short of international standards that every reasonable and impartial man would readily recognize its insufficiency." Through arbitral practice, we have essentially a set of misactions, I would say, or misconducts that would perhaps give a justifiable ground in which to invoke the fair and equitable treatment standard. And that could be, for example, and these are outlined in EU's new investment agreements and other bilateral investment treaties that are drafted nowadays, to specify, so what is actually meant with the FET and how far should it extend or even transcend. So denial of justice would be one such ground. Fundamental breach of due process would be another. Manifest arbitrariness, in other words, targeted discrimination on manifestly wrongful grounds. Abusive treatment of investments, in other words, that could be, for example, coercion or duress. And then I would say that a tribunal may take into account a specific representation given to an investor through the use or through the protection of legitimate expectations. This nowadays is more cumbersome, more problematic, and under, I would say, under attack. And that is whether an investor can say that it relied, for example, on transparency, but probably more so on regulatory stability, and that it had formed a legitimate expectation of what it could expect, what it was offered, and how it was planning its business in a manner in accordance with what has been specifically represented by the state directly or indirectly. So that was all those were the rights that you were talking about. Typically the rights that are offered through international investment agreements. As to the other part, in other words, obligations, that is a contemporary debate. And I have to add one that India, together with the Netherlands, is a leader in pushing for I call it a 2.0 international investment agreement landscape. But this discussion on obligations of investors merits a week or more of webinars on its own. So I will leave it at that, but I will highlight that it's a very contemporary debate, very topical, and much is being written about it, including I wrote with Professor Mfn Dautaj a book which touched extensively on these matters just recently.
Thank you, Mr. Dautaj. It was indeed a very eye-opening discussion. Mr. Dautaj, I remember you mentioning in your last answer to my question about the umbrella clause. Can you tell us, is it necessary to have an umbrella clause in an investment treaty?
Is it necessary? I mean, everything is a matter of debate. what you think is necessary and unnecessary to include in a treaty. It is ultimately a negotiation between two states. And as you may know, the investment treaty arbitration landscape and international investment law is not an isolated phenomenon, which means that it does not live in the vacuum of political realities, such as we are facing. In other words, a siege on globalization, a siege on free trade and investments in one shape or another. I mean, coming from both ends of the extremes in terms of politics. So is it necessary? No, nothing is necessary as such. Does it help investors? Yes, I would say, because what the umbrella clause does, it sort of, and to use colloquial language, it elevates a contractual claim into the regime of treaty protection. And that could be, for example, due to potential hardship. It establishes, sort of speaking, it establishes a contractual, it establishes a link between what is considered a contractual breach and the protection under international law. So it elevates disputes.
Thank you, Mr. Dautaj. Mr. Dautaj, my next question is pertaining to the jurisdiction. When shall an arbitral tribunal entertain a particular claim, and what shall be the scope of the arbitral tribunal in a dispute? And it's been consistently observed that the investors are the parties who invoke the jurisdiction of the tribunal. Has there been any instances where the states have invoked the jurisdiction of the tribunals?
To the last part, no, I have not seen that yet. It depends on, of course, it depends on what you mean with it. So nowadays, as I said earlier, when you spoke about, or we spoke about obligations, there is something that is called counterclaim. And counterclaim is very frequent in commercial settings, in commercial disputes. One party comes with their claim, and then you have a statement of defense and a counterclaim, typically speaking. Now, in the investment treaty regime, that used not to be the case. But nowadays, with the growing demand for investor obligations, for example, observance with environmental law or human rights or anti-corruption legislation, we have a growing scope and even appetite, I would say, and desire for counterclaims. In such counterclaims, I see a growing part to play for states in invoking the jurisdiction of the tribunal to hear in what manner the investor has potentially breached international environmental law or domestic environmental law, even though domestic law will be treated more with respect to the merits rather than the applicable law. To the first part of your question, there are three things you look at to determine jurisdiction. And please, if I didn't understand your question correctly, jump in and interrupt. Jurisdiction rationale materiae. In other words, there must be an investment. And that we discussed earlier, what constitutes an investment. There has to be jurisdiction rationale personae, and that is, there must be an investor, a legal or a physical party, for example, that is Indian, has invested in Sweden, and that there is a bilateral investment treaty between the two countries. And finally, jurisdiction rationale temporis, timing of the matters. So for example, when was the bilateral investment treaty entered into, and what does it say specifically with what types of investments are covered? Those after the treaty was entered into, also those before, when did the dispute arise, and so on and so forth.
Thank you, Mr. Dautaj. Mr. Dautaj, when we look deeply into investment treaty disputes, it is a complex mix of laws. So could you please tell us what is the substantial law that is involved, what is the procedural law that is involved, and when there is conflict of laws, which shall prevail?
Okay, so you have, first and foremost, the substantive law is treaty law. So that is international investment law. Then you have arbitration law, which is the institutional arbitration rules and the conventions. So, for example, suppose that you are under the auspice of the ICSID regime. You have the ICSID convention and the ICSID rules. If you are under the SCC regime, Stockholm Chamber of Commerce, you have the Stockholm Chamber of Commerce rules. And then if you want to enforce an award, you have the New York Convention. Okay. Then you have domestic law. Domestic law is not binding as substantive law, but it is relevant to ascertain and determine the merits of the matter. In other words, for example, if you're saying that it was an intervention with your investment and you're invoking fair and equitable treatment, then you may say that there was a revoking of license. And then there will obviously be a domestic matter about why was that? Was that within the state's right to revoke the license, and why? So that is not the law before the arbitrator as such, the applicable law, but it is relevant to determine the merits, which then is what makes or breaks your case. Then you have, as we just discussed, an increasing dilemma and complexity with respect to regime interaction. So this is something I think that you all should bear in mind in terms of very timely, very topical debates on investment treaty arbitration and international investment law, regime interaction. And that is, for example, nowadays, we have to consider human rights law, environmental law, EU law, and so on and so forth. So yes, the applicable law is international law. It's international law in the sense of international investment law and customary international law. But does that mean that we also have to adjudicate the matter substantively in light of human rights, environmental matters, and so on and so forth?
Thank you, Mr. Dautaj. Mr. Dautaj, what kind of remedy is usually sought in an investor-state arbitration?
Okay, so this is again differs, but not greatly. So I would say it's mostly monetary claims. Specific performance is very rarely that we would see a claim for a specific performance. In India, you had an interesting case just recently, which was Hardy Expropriation. Hardy Expropriation was a case of specific performance, and we saw how that went, and probably it has been appealed. It was determined in a district court in the United States. I think it was in Texas. But I would say mostly monetary claims, specific performance more rarely, declarative statements, in other words, interpretations of an agreement, I would say rather impossible or very less likely.
Thank you, Mr. Dautaj. Mr. Dautaj, my next question is pertaining to the global scenario. We are going through a global pandemic where the whole world is battling against this deadly virus, and certain governmental measures have been taken, which has completely tarnished certain obligations under the treaty. So will a state be liable for the measures taken in view of the novel COVID-19 coronavirus? And are there any exception to certain extreme conditions like a global pandemic?
Okay, so this is a very interesting question, I would say, highly interesting, and kudos to the entire team for bringing up not only standard questions, but also topical and also controversial questions but it is, as I would say, impossible to speculate because it is still an open-ended question. However, I can say states have certain rights within their police powers or within their margin of appreciation. The scope, extent, and degree of deference to the state's actions, and whether and how to adopt, for example, the doctrine of proportionality is already topical. It ties upon the matters we discussed earlier on dual fragmentation and regime interaction of investment law. So it is topical, and I expect that we will see more of that debate. I know for a fact that I'm writing several papers on it and already have, some to be published and some already published. I would say, to add on top of that, the last and final point, there will most definitely be situations where states have interfered with investments, perhaps, potentially, and even likely, in an illegal manner. And that could be with the hope or even subjective belief that it is acting out of necessity. In other words, necessity as stemming from the ILC draft rules on state responsibility. So whether this is such a necessity that protects certain measures that has directly or indirectly interfered with the investment of an investor that is protected under an international investment agreement, we have to see, and it depends very much on a case-by-case assessment. But I will say that this is a question that we will definitely see more of.
Thank you, Mr. Dautaj. Mr. Dautaj, as we are talking about the ILC draft articles on state responsibility, how far the concept of state responsibility is involved in an investor-state arbitration?
Can you repeat that question, because I didn't read it?
Mr. Dautaj, as we were talking about the ILC draft articles on state responsibility, can you tell us how far the concept of state responsibility is interlinked with investor-state dispute?
Okay. So in terms of the rules of state responsibility, what is more interesting in the investment treaty arbitration context is not the responsibility part, it is the attribution part and perhaps the defense part. So what are the defenses of the state? For example, necessity, which has been invoked in various, for example, water resources disputes. And that is essentially to say that, okay, there is an investment in water sanitation and services, but there is also a human right to water. And out of necessity, we have taken certain measures to provide our people with water. So that is one part, the defense, okay? The other part is attribution, and that is, for example, when can you bring a case against a host state? In other words, when was it actually the state that was taking measures as opposed to a so-called private actor? And you figure that out through the rules of attribution, which are to be found in the ILC draft rules on state responsibility, which are treated as customary international law.
Thank you, Mr. Dautaj. Mr. Dautaj, it is widely believed that having an arbitral award in one's favor is not the victory in itself. The real battle begins at the time of enforcement. So could you please elucidate about the enforcement, and also are there any immunities attached at the time of enforcement?
So this is again my favorite topic, obviously, because this is my topic of my PhD dissertation also, and of various recent publications and forthcoming publications. So I would just modify your question a little bit, and I would say that generally speaking, states voluntarily pay. Now, there has been some big cases where states do not voluntarily pay. And one obstacle then that represents or even manifests itself is the shield of sovereign immunity. And that shield is not with respect to jurisdiction, because as you know, the doctrine of sovereign immunity has two sides of the coin. One is from jurisdiction, and one is from execution, attachment and execution of an arbitral award. When you sign an arbitration clause in a bilateral investment treaty or other international investment agreements, or in foreign investment laws, you have been considered to waive the right to invoke sovereign immunity from jurisdiction. I would say that jurisdictional waiver includes matters that are incidental or ancillary to the arbitral procedure, which is also recognition and enforcement In other words, declaring a money judgment on the arbitral award when you seek to enforce it in a foreign jurisdiction. But what is the most biggest problem is execution and attachment. Because generally speaking, states are not considered to have waived their immunity, sovereign immunity, from execution and attachment of foreign arbitral awards, which means that the directly binding, final, and directly enforceable element of the arbitral award, which constitutes one of the fundamental elements of international arbitration, somehow is eroded because you're dealing with a sovereign state. And in that, what makes it cumbersome for the investor that now has a money judgment in its favor is that you need to find assets that are used for a commercial purpose as opposed to assets used for a public purpose. And there you have the entire dilemma when states refuse to voluntarily comply, which they do in the majority of instances, and then invoke the shield of sovereign immunity. Another concern, which I bring up in my PhD dissertation, is that the voluntary payment by states also rests on the fact that investment treaty arbitration is perceived as a legitimate institution. When that legitimacy is eroded, for whatever reason, it may not be as certain that states will voluntarily comply with the outcome. In other words, what I'm saying is that if you are attacking the means, it is more likely that you will attack the ends. As of today, the means have been considered legitimate, and hence the ends. In other words, the arbitral award.
Thank you, Mr. Dautaj. It was indeed very brief and very enlightening. The next question is the most sought after question I was able to see in few of the Q&As itself. That can you please elucidate about the concept of transparency in an investment treaty dispute?
The concept of transparency. So, as you know, in international arbitration, commercial arbitration, transparency was not a big thing. In other words, one of the strengths, so that was putting it colloquially, to put it less colloquially, one of the fundamental elements of international arbitration was confidentiality, not only privacy. So privacy means that you have your hearing in a private room, and confidentiality means that no one can know what has happened or the outcome of arbitration, unless you have to force or you wish to challenge the arbitral procedure. So confidentiality was a fundamental element of arbitration, the secrecy, which lay people, in other words, people that are not involved in high-stake businesses or actually in arbitration, would consider this a bad thing. They would say that it's bad, that it's secret. That's the word they would use. Investment arbitration started off, and to a large extent, when it's not ICSID arbitration, still has elements of secrecy. In other words, it happens in closed rooms. It's not available to the public. Awards are private and confidential. But because, as we discussed already in the very beginning, the first question, I think, or the second, the respondent is typically, or rather always, the host state. So who, and now I'm asking you a question, who stands the bill for both the arbitral procedure and, in case of a breach, the monetary claim that has been put forth and granted by the arbitral tribunal? Who is ultimately the payer of this bill? The payer of this bill is the taxpayers. In other words, the people of the country. And therefore, the argument has been put forth that confidentiality is not the manner in which you can cloak investment treaty arbitration. In other words, it needs to be transparent, or at least larger parts of it. And that has gained approval for obvious reasons, and I would tend to agree with those. And that means that nowadays arbitral awards are published, not only arbitral awards, but even interim awards, challenges of arbitrators. And that has had another positive outcome, or development rather, and that is that we have created sort of a de facto doctrine of binding precedents. So you can look and reflect at what previous tribunals have done to guide your interpretation of the law going into the future, which is good. And then you've had the Mauritius Convention that has clearly set forth rules on transparency and also elaborated on the role of intervention and third-party involvement in the form of amicus briefs and amici participation in investment treaty arbitrations.
Thank you, Mr. Dautaj, for answering all our questions. We'll be now moving on to the audience Q&A, and I can see a lot of questions here. So I would be posting one by one from the audience questions, and we can go ahead from there. So a participant, Ms. Shreya, she asked that what is the impact of foreign direct investment in an economy like India? What is a developing country during COVID-19, and what are the major actions that can be taken to improve the economy of India regarding FDI?
Whoa! So this is I don't necessarily want to step on anyone's toes, because this is a very political matter, and probably I mean, India's foreign direct investment policies are regulated by its government and by experts within its legal department, and so on and so forth. What I can say there is, to make it more general rather than specific, is that the entire purpose of investment treaty arbitration was not only to move away from diplomatic protection and to provide a neutral venue for dispute resolution, but it was to promote, facilitate, and attract foreign direct investments. So host states have not signed these treaties to be nice. They have done it not out of altruism or out of charity, but they have done so in order to attract and promote and facilitate foreign direct investments, and therefore economic growth of its host state. So is foreign direct investment necessary for India? Yes, as for any other state, whether it is India or whether it is the United States. For an emerging market, yes, perhaps even more so. You discuss also in your question the COVID-19 situation. There are two different ways of looking at it. One is, how do you rebalance, or how do you get, as Donald Trump would call the super V? In other words, you bounce back quickly from the economic consequences of COVID-19. And especially if you're India, I would say two things. One, continue the path it had already embarked upon since the late 90s. In other words, the revival of its economic policies, which included promoting foreign direct investment. So that's number one. Number two, I would say that it would be very wise indeed for India to market itself as the future hub for global supply chains. In other words, attracting some of the business from its main competitor to the right side of the map. In other words, China.
Thank you, Mr. Dautaj. Mr. Dautaj, the next question is from Vinod. He has two questions primarily. The first question is, if the party is not satisfied with an award which is to be enforced in India, would the Indian courts have a say in setting aside or upholding the award? And his next question is, in a multi-party dispute, what are the challenges faced during the dispute resolution?
Can you repeat? Start with the first, because I didn't hear. So,
okay. If a party is not satisfied with the award which is to be enforced in India, would the Indian courts have a say in setting aside or upholding the award?
Okay. So the answer is yes to both, but it depends. So first, it depends on, was arbitration seated in India? If the arbitration was seated in India, and it's not an ICSID arbitration because India is not a signatory to the ICSID convention, so for sake of argument, let me just say that if there would have been an exit dispute, then you have a self-contained system, which means that you cannot challenge the award at the seat of arbitration, and you cannot seek to challenge the enforcement at the jurisdiction in which you're trying to enforce the award. Okay, so now to the Indian example, because India is not a member of the exit convention. Suppose that this would be an UNCITRAL arbitration, or SEC arbitration, or ICC arbitration. If the arbitration would be seated in India, you can challenge. You can challenge the award under the rules of set-aside procedures. If the award is to be enforced in India, then you can challenge it under Article 5 of the New York Convention. And that could be, for example, on the basis of public policy, inarbitrability, or other procedural flaws and errors. And the other question there, please?
The other question was, in a multi-party disputes, what are the challenges faced at the time of resolution of the dispute?
This question I don't understand, so I cannot answer to it. But if the question is that multi-party disputes are complicated, yes, they are. How do you resolve that? I mean, if it is a matter of who gets what, I mean, it will be resolved by the arbitrator. But I have a hard time understanding the question, so I leave it at that. And if the person that asked the question is not satisfied with the first answer, please revert back to me so I can provide a more elaborate answer.
Thank you, Mr. Dautaj. Mr. Dautaj, the next question is from Mr. Anuj. He asks that, what is your take on transparency and confidentiality of the third-party funders in an exit arbitration, in specific with the working paper 4 of February 2020?
Let me say this, Mr. Tanuj, and that is, I don't have a very strong opinion on that matter. I don't write on the issue of disclosure of third-party funders. I think it throws up some practical issues every now and then, but I think it's more academically interesting than it is actually interesting in practice. I have an issue such as that now. I mean, the problem with disclosing is that you may be, how should I best put this? I mean, I would be inclined to say that some disclosure may be necessary in some situations, and it depends on the facts and circumstances, but there cannot be a black letter rule of full disclosure whenever there is a third-party funder. Let's put it that way. And that was very politically correct.
Thank you, Mr. Dautaj. Mr. Dautaj, the next question is from Preeti. She's asking, what are the advantages and disadvantages of third-party participation and funding in an investment dispute?
Okay, so third-party participation and funding are two different things. Funding, what is the benefit of it? I mean, there are many parties that may not necessarily have either the monetary strength to pursue an investment treaty arbitration because it's lengthy and it's costly, or it might be better for its liquidity. In other words, pursuing its business as per usual until the dispute is finally settled. And for that, they are willing to offer a specific amount to the third-party funder. What is the strength of including a third-party participant, or the necessity rather? It is, for example, to strengthen the global legitimacy of investment treaty arbitration. And that could be, for example, to include the EU when it is a matter of dual fragmentation or regime interaction, where a matter of EU law must or should be addressed. Or, for example, if you should address a matter of human rights, international human rights law, to have an NGO that is active with legal opinions on human rights and specifically on the interaction with international investment law.
Thank you, Mr. Dautaj. This is our last and final question from the audience. This is from Ms. Sharon Elsbeth. She is posting a question, which is, when we were talking about the COVID-19 pandemic and the defenses that are available under the ILC, this is only pertaining to the ILC draft articles. Are there any exceptions under the treaty in itself?
I didn't get the question. Please.
Mr. Dautaj, when we were talking about the COVID-19 pandemic, we were talking about certain defenses that are available under the Articles of State Responsibility. That is only pertaining to the Articles of State Responsibility. Are there any exceptions that is available within the treaty in itself?
So you're talking about exceptions such as force majeure, exceptional circumstances. I mean, and then the biggest exception to having any measures considered to be, for example, an indirect expropriation or an interference with the fair and equitable treatment would be those to say that these, I mean, you have, as a state, you have police powers, margin of appreciation, some sort of deference, and there is a scope in which you can move without infringing the protection that is generated or offered as a right through an international investment agreement. So yes, I mean, the state can act. And if that would not be the case, then the state would lose every single investment arbitration. But as you know, that's not the case. They win the majority of the arbitrations actually. So that's, you have another investor state bias and false perception that the claimant usually wins investment arbitrations. It is not the case, and it's not the case specifically for that reason. In other words, the state has scope in which to maneuver.
Thank you, Mr. Dautaj. It was indeed a pleasure for me discussing all the aspects with you. I would now hand over the floor to Mr. Dev for his concluding remarks.
Thank you, Sameena. Thank you, Mr.Yilli Dautaj. It was really a wonderful session. So I thank all the attendees for your patience, listening, and considerations. So all the unanswered questions or any feedbacks, you can write to us at kfci.ad@gmail.com. So on completion of the first day on the topic of investment arbitration dealing with the KFCRI sector specific webinar series, we'll continue on tomorrow with the topic dispute prevention and mitigation and other alternate dispute resolution mechanisms on investment related arbitrations. Thank you. Thank you all.
Thank you very much.
Thank you, Mr.
Thank you, Professor and Arbitrator. Thank you to the entire team. It was my pleasure.
We can catch up tomorrow with the subsequent development of investment state arbitrations.
Yes, that would be a fantastic opportunity to speak about that. Thank you very much.
Thank you so much.
Bye-bye.